Thank you. And welcome everyone to the Office of Affordable Housing Programs office hours. It's a Q&A session on HOME-ARP. And today we're going to be focusing on implementation and planning challenges. So first I want to introduce myself. I'm Ginny Sardone. I'm the Director of the Office of Affordable Housing Programs. And I have with me here today Henrietta Owusu, who's the Director of the Program Policy Division, Walter Howell, who is Assistant Director of the Program Policy Division, specifically for the HOME-ARP program. And then also on the line, but not in the room with us, are a variety of additional OAHP staff who are subject matter experts on different aspects of HOME-ARP and will help answer your questions. So with that, let's get started. Okay, so as I mentioned, our topic today is implementation and planning challenges faced by participating jurisdictions and other program participants in sort of getting their HOME-ARP programs up and running. And so sort of our agenda for today is, after I sort of make a couple of opening remarks, we will be going over the current status of the HOME-ARP program nationwide. We will be talking about and walking through administrative and planning topics that many of you are working on right now. We'll also discuss written agreements. We'll talk about reporting, and then we'll quickly introduce some HOME-ARP resources that may be of use to you. Slide, please. Okay, so just to take a step back for 1 minute before we move forward again on to implementation, really talk about what Congress was trying to do with the HOME-ARP program. They were looking for a vehicle for one-time funding, in this case of $5 billion, to facilitate targeted investments in housing and supportive services for several vulnerable populations, including persons experiencing homelessness or at risk of homelessness. And they ultimately, after looking at a number of different programs within HUD as a possible platform, decided to use HOME. And the reason they wanted to use HOME was they were really hoping that HOME participating jurisdictions would use it as an opportunity to make strategic investments that would leave assets, sort of assets to serve the community and to serve these populations over a long term. And so when they gave us this, when they wrote the statute, they obviously had to give us waiver and alternative requirement authority to alter the 2 existing HOME activities that were carried over into HOME-ARP. That's rental housing and tenant-based rental assistance, and also to permit us to create 2 new activities that don't exist in HOME: supportive services and non-congregate shelter. And then obviously we had to adapt the program to serve the 4 qualifying populations that Congress defined in the statute, as opposed to the income-based approaches that we've always used in HOME. Slide. So, there's a lot that, that we were able to do with HOME-ARP, with the waiver authority that we had and the alternative requirement authority. And it really does provide PJs and other program participants with a lot of flexibility across all 4 of these eligible activities. However, HUD certainly recognizes that these new flexibilities and these new opportunities really present challenges to participating jurisdictions and other program participants. And those are the things that you are grappling with right now. So we have new and different activities, don't exist in HOME, but aren't exactly the same potentially as they look in other programs, like the homeless programs that we administer here at HUD. And these qualifying populations, We don't sort of use those types of definitions. We don't target in that way in the regular home program. This is something more along the lines you might see in some of the other CPD programs. However, Congress didn't write the qualifying populations definitions in the same way in all cases as they're used in other in other programs. So that is certainly a challenge for you all. And also sort of deciding how, figuring out how you're going to determine whether applicants actually meet these QP definitions. Obviously another big challenge for you all. A lot of unfamiliar rules in HOME-ARP. So for instance, rental housing may be something that you do quite frequently with your regular home funds. However, it looks a lot different in HOME-ARP. We were able to do away with many of the requirements that apply to regular home and sort of establish other requirements that are more appropriate to the populations that we're serving here. But these are new rules and things you're not familiar with, a big challenge for you all, we certainly understand. And even things that are new opportunities, things that are not permissible in the regular home program. For instance, sponsor-based rental assistance, or master leasing options for rental housing. Those things, as great as they are not things that you're used to doing, at least not in home. And we understand the challenge that that poses to you all. So I'm going to turn it over to Walter to sort of walk through a status of the program, and then we're going to dig in to a lot of the administrative topics that we hope to cover today and your questions. So Walter.
Thank you, Jenny. So I want to give a quick update on the allocation plan submissions and acceptances. So initially there were 648 PJs that were eligible for the HOME-ARP allocation. 5 PJs declined the funds, and so that left 643. As you all know, last March, there was a deadline for all allocation plans to be submitted by March 31st. And so all 643 were submitted. As of February 2024, 630 plans have been accepted, which is 97%. And so I want to take this opportunity to acknowledge this milestone and encourage folks to give themselves a pat on the back, an acknowledgement and so forth, because that is something that is commendable. There are still 13 plans that are either in a resubmission status or review status. And so hopefully they'll get to the finish line soon. And I just want to highlight that Direct TA is still available for allocation plan developments or modifications, not just for implementation at this time. Okay, how are PJs planning to use the HOME-ARP funds? As you can see from the pie chart, 50% of the funds are being used towards rental housing. 1% is being used towards nonprofit operating and capacity building. 5% toward TBRA. 14% toward non-congregate shelter. 17% towards supportive services, and 12% towards administration and planning. Given the low percentage in nonprofit operating and non-capacity building, for those who may want to reconsider, I encourage you to go back to the notice to, I believe it's page 67 and 68, just to get a refresher on what that entails, just in case you want to divert some of your funds to that cause or to that activity. To the right of the slide, you see housing goals. So based on the allocation plans that have been accepted, there are 21,940 units being produced. And there are 24,705 units that are supported with either, or that will be supported with either TBRA or supportive services. As you all know, up to 15% of the HOME-ARP allocation could be used towards, or can be used towards, administration and planning. 5% before the allocation plan approval, and after allocation plan approval, remaining funds up to 10%. Okay, now that we've talked about that milestone and all of these funds being distributed across the country and the territories of the United States, now we get into with to whom much is given, much is expected or required. And at the administration of your HOME-ARP programs, it's a great responsibility. In the notice at section 8A and in CFR 2492.504A, it discusses program administration responsibilities. PJs are responsible for the overall management of day-to-day operations. They're responsible for the development of policies and procedures to implement the plans and to maintain grant oversight and coordination. PJs must ensure that HOME-ARP funds are used compliantly, and one way to ensure that is to have strong, sound internal controls to support compliance and capacity. And not only do internal controls prevent waste, fraud, and abuse, but they also prevent errors and irregularities. They help to make sure that corrective actions occur, and they also excuse me one moment. They also help PJs to identify problems that may be occurring with their programs. PJs are also responsible for enforcing the requirements of the required written agreements, and they're also responsible for responding with appropriate actions when performance problems arise. Now, at the project level, PJs are responsible for funding, managing, and overseeing eligible activities, including reporting. They're responsible for selecting projects and activities based on the allocation plans. They are responsible for ensuring projects serve HOME-ARP QPs. In particular, they are responsible to ensure that at least one eligible HOME-ARP activity is available or that QPs have access thereof. They're also responsible for selecting and the oversight of partners, which may include subrecipients, developers, contractors, and/or service providers. Lastly, they are responsible for the setup and funding of projects in HUD's information system, which we know as IDIS, or the Integrated Disbursement and Information System. They're responsible for timely processing of invoices to expend funds, which also helps providers get paid timely. They're responsible for reporting accurately and good record keeping. And lastly, they're responsible for ensuring that capacity exists to manage projects, the program office or program responsibilities, and the activities under their HOME-ARP funds as applicable. And with that, I'm going to now turn it over to Henrietta.
Okay, good afternoon. So Walter talked a little bit about assessing internal capacity and as a key program administration responsibility. So having the capacity to administer a grant involves several key skills and responsibilities. The first is knowledge, right? Knowledge means that you're familiar with the guidelines and goals and objectives of the program, and you understand eligibility criteria, what is an allowable cost, reporting obligations, the purpose of the grant, I would be remiss if at this point I don't plug Building Home, which is as Judy said, HOME-ARP was placed in the home frame. So to have a really good understanding of HOME-ARP, it's really important that you understand home. We have an amazing training tool on the Ad Exchange that walks you through the home program requirements. And I think it does give you that contextual framework for understanding the HOME-ARP program. So, you guys already, I guess, up to speed on the knowledge part, because you're making yourselves available for this question and answer session, as well as other trainings that we're doing. So that's the knowledge part. The skills and abilities part, that's something that you get through practice and it's built over time. But another thing that in terms of administrating a grant that you need to really consider is experience and time, right? And as you go through that exercise, you also have to be able to identify the gaps that you have and figure out a way to expand your capacity where the capacity doesn't exist. Next slide. So that, assessing the gaps.
Oh, I guess I got it.
Can you guys hear me? You guys are having a hard time hearing me?
That's much
This is
better,
better?
Henrietta. Yes, thank you.
Better? Okay, sorry. So assessing external capacity involves looking at what opportunities are created by a new program. Ginny talked about that. And when I say be creative, I'm not asking you to reinvent the wheel, right? Be creative does not at all mean reinventing the wheel. It's scanning your environment and looking at who's doing what it is that you need to do. I understand that under the normal home frame, a lot of the activities, the qualifying populations that you're going to be dealing with is very different from what you deal with in the normal home frame. But you do have partners in the community who have the experience of serving qualifying populations, right? And so, be creative means, trying to look at some of their skills and experience and bringing them into the fold, whether in a consultancy. No, I don't think so. Okay. I think it's good. Understanding, looking for organizations that have, for example, strong financial management or programmatic expertise and partnering with them. Anything that you can do that makes it a lot easier to administer the grant is what you need to do. And as Walter said, if you have organizations that at this point maybe don't have the capacity, consider using your nonprofit operating and capacity building funds to increase their capacity to undertake eligible activities. Okay, so these are public funds, and like any other public fund, the administration of it needs to ensure fairness and consistency, and there need to be very clear rules and guidelines on how you're administering your program, right? So policies and procedures are super, super important because it does ensure that consistency and fairness. A good example of a policy is when you write down, for example, your tenant selection policy for rental housing. And, the policies are not a standalone thing, right? When you have a policy, you need to have a process for how that policy is implemented. That's your procedure. Your procedure provides direction and instructions to all stakeholders in the process on what needs to happen and when and how. So an example of a procedure, for example, is documenting QP eligibility is a good example of a procedure. So as I said before, your policies and procedures are so super important. Here at HUD, we hear often from PJ staff and leadership about, different staff people leaving, and because they left, there's a gap in the administration of the program, and it has, put down the capacity of the participating jurisdiction and its responsibility to administer the grant. But that's in part because we don't do a very good job of writing down policies and procedures. Policies and procedures are a roadmap, right? If you have that, the policies and procedures written down, it provides context for new staff coming in. You also have to understand that your policies and procedures are the things that are reflected in your written agreements. Your home requirements, your HOME-ARP requirements are all minimum requirements that HUD sets. If you have a program design that asks for something different, you want all of that in your written agreements, and you want your policies and procedures to be reflected so that you can point to it in your written agreements and be very clear on, responsibilities and roles and all of that kind of good stuff. So, please make sure that you are pointing to these policies and procedures in your written agreements, and that you're including documentation and requirements, as well as retention policies, so that you have a really good basis for your record keeping. Also develop good compliance protocols based on your policies and procedures, because it allows you to stay compliant, which is the purpose of this. You don't want to repay these funds, right? Remember that. If you misuse the funds or you can't demonstrate eligibility, you've got to repay. So you don't want that. And so if you develop good compliance protocols, it'll ensure that you stay on track. Your policies and procedures are a living document. It's got to be regularly updated. Do not just create them and store them away or put them on the shelf. That's not the purpose of it. It's a living, breathing document, and it's something that you should be touching at all times, and it should be guiding your implementation. So what is a written agreement? A written agreement is a contract, right? It's a contract between the taxpaying jurisdiction and any of the entities that it is providing funding to for an activity or to administer a program. It legally binds the HOME-ARP funds to the specific project or program. It also is something that needs to be executed, right, before the PJ disperses any HOME-ARP funds for any project or program, right? Your written agreement is your commitment. It's your official commitment, right? And you cannot disperse funds without it. It must be a separate standalone document, separate from any mortgages, deed of trust, promissory notes, or any other loan documents that you have. An effective written agreement defines the activities that need to be carried out. It tells you the source of funds that have to be used. It clearly states the responsibilities and the roles of all the entities involved in the project. It ensures that you can enforce compliance and support monitoring performance. It also informs all the parties of all the applicable HOME-ARP program rules, as well as other federal regulations. It protects and manages the HOME-ARP investment. It's your project management tool, right? It helps to ensure productivity and performance. It presents a very clear and concise understanding of program requirements. It shouldn't just be a recitation of citations without it explaining what the requirement is that needs to be followed. Okay. So what's an ineffective written agreement? An ineffective written agreement is one that's drafted for different programs. We see that a lot here at HUD. When you have a template that you use for all the programs that you administer, what's wrong with that, right? You always run the risk that you're not adequately representing the program requirements of the particular program that you're entering into a contract with others for. Your written agreement should not include ambiguous or contradictory regulatory citations. You know, when you have a HOME-ARP written agreement that has Part 570 citations in it, you're already on the wrong track, right? It shouldn't have unclear wording regarding duties and responsibilities as well as obligations. It can't have parts that are hard to understand or difficult to navigate and show exactly, you know, what sections refer to duties and obligations. It should have a very clear enforcement mechanism, as well as all the normal default clauses that you see in contracts. And it should have enforcement and some of the other default provisions like, being able to amend it and under what conditions the agreement should be amended and things like that. Assignment, if there's an assignment clause, all those things that are normal in normal contract stuff should be a part of your written agreement. And if it's not in there, it makes your written agreement ineffective. So I've said this already, and I'll just go over it really quickly because written agreements are so important in both the HOME program and the HOME-ARP program. So your written agreement is your management tool, right? It ensures that you're appropriately managing your projects and monitoring, that you're communicating expectations across all partners, that you're able to track progress against agreed upon project and program goals, schedule, and conditions. Time and time again, we see written agreements without a timeline. What does that say? You're just providing funds and you haven't actually put in place benchmarks on when when you expect different things to happen. That's not a very effective contract. It should incorporate contract performance in a way that allows you to be able to monitor and also include in your future funding decision making. So just a few tips and reminders about written agreement. So don't forget, Section 8 of the notice is where you find the provisions that must be in a written agreement between a PJ or subrecipient and any owner developer. We are working on written agreement checklist, and we also want to work on some providing some templates. It's in the work, in the works. I know we've been talking about this for a bit, and we've been working very, kind of on a fast and furious pace with our tier providers to try to get you this training tools as quickly as we can. But there's so much that we've had to do in terms of standing up this program that we don't have some of these things for you now. And I know that you need them right now, but we're working quickly to try to get them out. Make sure that you're amending your agreement when your project changes. If there are any changes in the agreement, in the project, make sure that you're amending your agreement accordingly. Ensure that your agreement provides for proper oversight of activities, including periodic inspections. Ensure that your agreements are legally binding. That's really, really important. We see that here a lot when PJs have signed agreements and it doesn't include a dated signature of each person signing the agreement. That is not a proper agreement. So make sure that your agreements are legally binding and can, stand the test, so to say. Use your attorneys. And make sure that they're legally reviewing your contractual documents so that you're not putting your agencies at risk. Like I said, for HOME and HOME-ARP as well, if we can support the use of the funds, it requires repayment, and it's repayment from non-federal funds. So you're obligating your agencies when you sign these written agreements, and you want to make sure that it's legally sufficient and that it's got that legal review. And also ensure reporting and record keeping. It's really, really important that whatever the reporting and record keeping requirements that you want to impose on either the developer or whoever the partner is, that you clearly specify it, right? So that you have a standing if they default. So just to talk really quickly about HOME-ARP performance reports. So for rental and TBRA, it's very similar to the HOME program. For those of you that administer HOME, there's not a lot of change there. So for rental, you need to report on the number of HOME-ARP assisted rental units. You need to report on the household characteristics of the units that have been occupied. Rental operating is separate, but it's a connected activity to the main rental activity, and the accomplishment data is then transferred from the rental activity to the operating. For TBRA, it's the number of HOME-ARP assisted households, the household characteristics of the units occupied, funding limited to the amount committed for assistance to the households. For the two, activities that are not in regular home, again, supportive services and non-congregate shelter, the reporting is slightly different. So for supportive services, you need to report on the aggregate number of homeless and not homeless households. And household level data is not required to be entered in IDIS. But remember that there is a quarterly reporting requirement for supportive services. And I know that in looking through IDIS, a lot of you that haven't started that quarterly reporting want to put a plug in. I know that we have been talking about doing some IDIS tutorials. I think we have one on rental housing up there on the HUD Exchange, but we also have a really nice fact sheet as well as a webinar that walks you through how to set up your supportive services activity and fund it and draw down on it and then close it out when it's done. So please go on the HUD Exchange and look at it and make good use of that resource. We're working on the IDIS tutorials, but even as the tutorials are not up there yet, I don't think it's I think we have enough information there for you guys to start reporting on your supportive services activities. For non-congregate shelter, it's the number of HOME-ARP assisted NCS units. There's no beneficiary reporting required. The units of NCS converted to another eligible use have to be reported on, as well as annual reporting during the restricted use period or until the NCS unit is converted to permanent housing. So we have a lot of upcoming guidance. In the next few slides, we have links in there. I know that a lot of you are going to take the slide deck home as a takeaway. So it's got links in there that you can click on, and it will take you to a lot of the training that we put up on the exchange. For upcoming guidance, we have for written TA products, we're actually doing a product on non-congregate shelter that walks through the due diligence considerations for acquiring properties. We have another one on property standards as well, setting the minimum habitability standards. We have QP eligibility, record keeping and supporting documentation requirements, project file checklist, and sample QP eligibility forms. Written agreement checklist are coming. We're also working on a capacity assessment tool for community development executives to kind of walk through some of what I just talked about in terms of assessing internal and external capacity. We do also have an elected official series to help your elected officials, your biggest cheerleaders, right, to tell the story of how HOME-ARP funds are being used, to keep all the stakeholders engaged, and also to impress on them the need to timely expend these funds. Right. We have upcoming HOME-ARP TA sessions. So implementation clinics, we have about 20 deliveries of the virtual clinics. This started in October of 2023, and it includes activity-specific clinics such as substantial amendments, preferences, QPs, policies, and procedures. I think last week was referral methods. And the next presentation, I think, is on QPs, and I can't remember the date to that. But, registration is through the listserv. So just make sure that you have subscribed to the mailing list and you will get that information. We also have in-person clinics that we're planning. We're looking at up to 43 deliveries. We expect these to start late April of this year. It will focus on specific activities as well as policies and procedures. We're looking at least one delivery in each HUD region, and it will address each of the 4 activities. In prep for the clinics, we're working on written products and tools that can be used for the clinics. Okay, so like I said, I'm not going to go through each of these. These are just the links to some of the resources that we have on the exchange. So once you get the slide deck, please take a good look at it. And we do have a lot of training up there. So please visit the HOME-ARP page frequently because we're constantly updating and putting things up. Again, just walking through some of the written resources that we have on the exchange. HOME-ARP IDIS guidance, we do have a lot of guidance on there. I just also wanted to put in a plug. We're doing some in-person IDIS trainings across the country. The registration for that is not through the HUD Exchange. It's actually through your field office. So just want to, let you know so that you keep an eye out. I know that the next IDIS clinic is going to be in Denver. It's from April 8th to the 9th. If you have not received a registration from your field office, check in with them. There's limited space, so you want to be, and it's on a first come, first, sign up basis. So you want to reach out quickly if you don't have that information and you're in the Denver regional office. You want to reach out to the field office and make sure that you have an opportunity to participate in this wonderful training. The next one after that would be in the Fourth Ward field office, and it's being held on April 11th to the 12th. And registration, I think it's probably started for that as well. So if you're in the Fourth Ward region and you haven't heard from your field office on it, please reach out. Like I said, there's not going to be registration for this through the listserv. It's going to be through the field office. So you want to check in with them. And then the last session in April is going to be in the Los Angeles field office. And I think registration for that is probably also out right now, but that's in late April. It's from April 22nd to the 25th. So again, reach out to the LA field office if you haven't heard from them already about registering for this training. Walter, if you want to just go back, I just wanted to also point out, I talked about this, but just wanted to point out that for supportive services, the quarterly reporting for supportive services, for example, as you know, we do have the supportive services activities webinar and the fact sheet, and it's really, really, really good in walking you through the IDIS screens. So please take a look at those resources. HOME-ARP assistance, of course, your field offices, right? We do have these quarterly office hours sessions. This is our second. The next one is going to be sometime in June. The HOME-ARP at HUD.gov remains available for questions, and we're, really catching up. We had a bit of a backlog for a little bit, but I think at this point we've cleared most of it and have answered a lot of your questions. Please keep on coming. They're really good, and it also informs the TA that we get out because it tells us what the need is on the ground. So please keep it coming. And as always, make sure that you subscribe to the HOME-ARP mailing list so that you can get information about all the trainings and other program updates as they're available. And, this is something that I did not think in my government career I would ever be able to say, but HOME-ARP has been that kind of a program. We do have a lot of funds in terms of for technical assistance. So Direct TA, I think Walter mentioned that Direct TA is available to Home PJ. So if you have a need and if you're having challenges implementing, please go on the HUD Exchange and put a request through the TA portal. It comes directly to our office and we'll respond to it. Or if if that's too much, just check in with your field office and let them know that you need technical assistance, Direct TA, and it will again come to us. And with that, I'll turn it over to Andalyn. Thank you.
All right, thank you so much. And thank you to the entire OAHP staff for coming in today and answering these questions. My name is Andalyn Nesbitt Rodriguez with ICF, and I'm joined today by my colleague Jessica Lurs with APT Associates, and we're here to moderate this Q&A. We've been getting a lot of great questions through the chat box, so please keep those coming. We're going to get to as many of them as time permits today. So with that said, we're going to jump right in. Starting with some general questions. Okay, can a preference for people aged 55 plus be established in order to create rental housing units for that subpopulation? That's our first question.
Thanks, Andalyn. This is Caitlin Renner. I'll take that one. So in terms of a preference or limitation for persons 55 plus, assuming that the questioner is talking about senior housing that would exclude seniors that also would have children in their family. We've been advised that this is permissible if another funding source in the project is, specifically requires this type of preference or limitation. But if there's not another funding source in the project, like a 202 or 811, that would require the housing be limited in such a way, and the project would not permit seniors with children living with them, then we strongly recommend you reach out to your FHO contact in your field office.
Thank you so much. All right, next question. If a PJ funds an activity that serves two of the QPs, qualifying populations, and funds a different activity where the remaining two QPs are served, does this fulfill the requirement of serving all of the QPs with the program? In other words, will the portfolio of funded activities comply with the QP requirement, even if any one activity actually serves less than the 4 QPs?
Right. So it technically would fulfill the requirement of the program to provide access to all 4 QPs across a PJ's entire HOME-ARP program. Individual projects may be limited to less than 4 QPs. However, it's really important to remember that limitations should only be applied if they're absolutely necessary. If a PJ can provide a preference instead of a limitation and still achieve its goal, for example, a PJ might have a goal of providing housing for people that are chronically homeless. If the PJ can implement a preference and those persons who are chronically homeless then are served first, but the project doesn't exclude others, let's say it's rental housing, then that project is open to all 4 QPs. And there's no concerns with limiting access, even though the scenario described would meet the overall intent of the statute to provide access to all 4 QPs. Individual projects that are limited in such a way could end up having certain fair housing concerns. And so to avoid getting into any of those kind of issues, PJs really need to think through whether there's an absolute necessity to have a limitation in that way, or if, again, if their program goals can be accomplished through a preference, which is less problematic.
Thank you.
Well, we have another question somewhat related. Can you explain HOME-ARP qualifying population criteria versus the home eligibility?
Sure. So the HOME-ARP qualifying populations are defined in the notice. There are 4 qualifying populations, as we discussed, and some of those definitions of qualifying populations do, include several criteria in order for a family to meet the definition of a QP, and some of the criteria may include income, but the requirement for occupancy in HOME-ARP rental or NCS or receipt of TBRA or supportive services is just meeting the definition of a QP. So income may not even come into play, especially, for example, with QP3, which is the domestic violence, sexual assault, trafficking QP. Whereas in the home program, of course, the requirement is that all persons assisted with home assisted housing must be low income.
Great. Thank you for that. And then we had a couple questions that came in around substantial amendments. And so does the HOME-ARP allocation plan need to be amended before a NOFA is sent out? So, having the inclusion of a preference wasn't maybe mentioned in the allocation before. The person who entered this question in said that they wanted to amend the plan to include preference languages and just wanted to know how doing that.
Yes. So if the PJ intends to design the NOFA or RFP in such a way that it would, be more favorable to projects that included a certain type of preference. So like maybe they're providing more points to projects that will provide a preference to the chronically homeless, for example, then the PJ needs to amend its allocation plan before putting out that RFP or notice, because by putting out that RFP or notice, they're implementing that preference in their program. We've also had questions from PJs who did not include any of that kind of criteria in their NOFA and then received projects, maybe from certain organizations that have a mission to serve, you know, certain QP or subpopulations of QPs. And so they were, even though it wasn't in the NOFA, maybe they're proposing a project that it might include a preference. That's fine, but before the PJ awards funds to that project, the PJ would need to amend its plan if the PJ did intend to F-fund that project. And we would remind PJs the preferences are supposed to, you know, be reflective of the needs assessment and gaps analysis in your plan. So, you know, just because you've received a proposal that has a preference, does it actually meet, you know, the goals of your HOME-ARP program?
Great. Thank you so much. Okay, we're going to move on and cover some rental housing related questions really quickly, but we will come back to general questions. So please keep those questions coming in the chat. So moving on kind of to rental, can a landlord use hotel law for rentals as opposed to lease?
Thanks. This is Martha Murray. No, a landlord cannot use hotel law for rentals because HOME-ARP rental projects are considered permanent housing. So it's not governed by local or state laws. If the PJ is going to use home funds to acquire, rehab, or construct rental housing, then each household that occupies a HOME-ARP unit has to have an executed lease that complies with the tenant protection requirements that are outlined in the notice.
Great, thank you. Can a PJ invest home and HOME-ARP funds in the same rental project?
So this is a very frequent question to the HOME-ARP mailbox, through field offices and on these webinars. So yes, a PJ can invest both home and HOME-ARP funds in the same project. However, we strongly recommend that the home and HOME-ARP funds not be invested in the same unit. Doing so would make it exceptionally difficult, almost impossible to sort of maintain the proper unit mix in the project throughout the project's affordability and compliance period. So a PJ would have to go through cost allocation in order to properly attribute the eligible development costs according to the actual cost of the assisted units by the funding source. And then I also saw in the chat, there was sort of a similar follow-up question. If you were providing home and HOME-ARP funds to a project, could you combine the requirements into one written agreement? And the answer is no. There are two separate programs with separate requirements. So you would have to impose the requirements via two separate written agreements.
Thank you so much. All right. Under what circumstances might a PJ capitalize an operating cost assistance reserve?
So careful project underwriting, it's essential. And including, determining if a project's operating income is sufficient to cover the operating expenses throughout the 15-year compliance period. So if a PJ determines during its underwriting that there are projected operating deficits that remain after the anticipated QP household rents are applied to the QP unit's share of operating costs, then the PJ may want to capitalize an operating cost assistance reserve. We think that HOME-ARP projects that are 100% HOME-ARP funded, they'll likely need a capitalized reserve because many QP households will be unable to pay rent that's sufficient to cover operating expenses, which will obviously result in a deficit. That's why we're encouraging PJs to work with local PHAs, other state or local agencies to obtain project-based assistance for these projects. And that would provide a rental subsidy that would cover sort of the operating costs and help with the financial viability of the project through the long term.
Thank you. And if a PJ is capitalizing rental operating costs assistance reserve, is a separate written agreement required?
No. So a separate written agreement is not required, I would say probably not even permitted. If the PJ determines during project underwriting that the operating assistance is needed to ensure the financial viability of the project, through the 15-year compliance term, then the written agreement has to include the amount of the capitalized reserve based on the total operating projected deficit that's associated with the QP unit. So it has to be included all in one written agreement because it is an eligible cost. It's not necessarily an eligible activity, right? It's an eligible cost of HOME-ARP rental development. So you have to include all of the costs in, you know, as an attachment in the sort of sources and uses and budget that goes along with the actual written agreement.
Perfect. Thank you so much. We're going to come back to rental housing in just a moment, but right now we're going to transition and talk about TBRA a little bit. Jessica?
Actually, we don't have many questions about TBRA, so I think we're going to jump to supportive services. But if we find some TBRA questions, we can certainly address those. And please, if you have any TBRA related questions, feel free to add those to the chat. But I think we'll go to some of the supportive services questions. And like Andolyn said, any topic right now, feel free to put it in the chat. We'll try to make time for as many as we can today. So one of the questions we had was under the supportive services activity, are security deposits first and last month's rent eligible services?
Hi, this is Diane Thompson. I'll take that one. Yes, they are both eligible financial assistance costs under the HOME-ARP supportive services activity. So a security deposit, it can't exceed 2 months rent, and it is separate and distinct from the cost of first and last month's rent. So I suggest that PJs just take a look at the supportive services section of the notice for the specific requirements for each eligible cost.
Perfect. And another one about supportive services. So how do we determine if an eligible service is needed? Are there different eligibility criteria for different services? And then in quotes, just other than meeting a qualifying population criteria?
Okay, that's a good question. So eligible costs for supportive services, they have to be necessary to assist the qualifying population, right? They must prevent homelessness or enable qualifying households to obtain and maintain housing. The individual or household can't already be receiving the services through another program. And the PJ needs to develop a policy on documenting need, which could include things like self-certification, observation, supporting documents provided by the program participant. But because many of the eligible services include specific eligibility requirements, policies and procedures on how to determine need should definitely account for the type of supportive services that the PJ plans to offer or is offering.
Great, thank you.
Sure.
And then we have another supportive services question here. What is the most effective way to monitor supportive services?
Yeah, PJs, they really need to have policies and procedures on this, right? When drafting policies and procedures, the PJ should ensure there's a way to demonstrate that the requirements for the particular services are being met, right? We are developing model program tools for the supportive services activity, and it will include a monitoring tool. But until those are available and published, the PJ may want to consider using things like a checklist to outline the requirements of the particular service that's offered and use that to, ensure or determine compliance.
Great, thank you.
Sure.
We have a couple of kind of general questions that we want to go back to, and thinking about sort of the RFP process, and want to ask, in one of the HUD webinars, it said that RFPs were not required for HOME-ARP. Is this correct?
I can jump in on this. So this requirement is going to be the same as the HOME program. There are no requirements for project selection or subrecipient selection. Procurement does not apply there. Procurement only applies when a PJ or a subrecipient is engaging a contractor, which has a specific definition under home and HOME-ARP. So no, there's no requirement, and I saw we received several questions on this, that the PJ use an RFP to select the specific like rental project, for example, that's going to be funded.
Great. And another one kind of general question, but related to prioritization. How do we best prioritize services for persons experiencing homelessness while staying within the program guidelines?
Hi, this is Shannon Hansen, and I'll take that question. So in order to best prioritize services for persons experiencing homelessness, there are several things that will need to be considered. The first thing, and I know it's been mentioned, but we want to emphasize the fact that the PJ has to, before they implement any preference or method of prioritization or limitation, it has to be established in the accepted allocation plan. So the first step would be making sure that that's been in the allocation plan and it's been justified with the needs assessment and gaps analysis. The next thing to kind of consider is looking at what supportive services are being offered. So if we're looking at how to prioritize services for people experiencing homelessness, what that individual or household needs might be different. What they think they need might be different than what we think they need. So the first and foremost thing is making sure that the service being offered is something that they agree to, and then there's choice obviously with that. So the PJ could set up their supportive services in a couple of ways in order to prioritize services. So they could set up through their referral method where an individual gets referred to or becomes eligible for HOME-ARP supportive services. And then the PJ has to have identified which supportive services they're going to offer. And so then that household will be able to possibly select, and work with the providers to see which would be more appropriate. More likely, however, would be that each of the supportive services may have its own almost like project specific wait list. If there's a slot open, then that's how people would be able to access that service. And again, based on what their needs are and what their choice is too. So if you have a household who is receiving one type of supportive services, they're not excluded or precluded from receiving another type of supported services or another HOME-ARP eligible activity. So if there's a household receiving case management, for instance, through supportive services, then they could also potentially receive, if the PJ established policies and procedures and we're providing also financial assistance for rent, that household could also receive rental assistance through that supportive service based on need and how it's set up in the PJ's policies and procedures. So based on those types of things, that does depend on what the PJ wants to set up, like I said. So whether or not it's prioritized based on the household coming to you and then determining what's needed and available, or based on each specific supportive service and then having the referral done directly to that supportive service. And either way, just again, the PJ having the policies and procedures and then following those policies and procedures will be the way it's done. But in establishing those, just to consider the different methods and ways in which those could be offered. Just lastly, I just want to say too, I think sometimes based on some of the questions that come in through the mailbox, there's a bit of a misunderstanding, thinking that if somebody is eligible for a supportive service, then they get to choose from all of the supportive services that are listed in the notice, when in actuality, each of the supportive services offered have to be established with policies and procedures, and can't be offered until those are in place. So it'll be really important in the planning process for PJs to establish that.
Thank you. That's a really important part to highlight. One other question about substantial amendments that we want to kind of double back to, and then we'll get into some non-congregate shelter questions. But if a PJ did not establish preferences or limitations, but the PJ, we sort of answered this one already, but the PJ received an application for funding from a nonprofit that only serves a certain QP population, must the PJ amend their plan? And Caitlin, I think you spoke to this last time, but if you want to just
Sure.
reiterate.
Yes, an amendment would be required if the preference was not previously included in the plan. But again, HUD would encourage PJs to consider, was that proposal responsive to your RFP or NOFA? Does it meet your needs? It's no requirement that you fund it, but certainly make sure that when you're adding a preference to your plan, that you're tying it back to that needs assessment and gaps analysis. So that consideration is necessary.
Great, thanks. All right, Andolyn, get some non-congregate shelter questions.
Thank you so much. We're going to transition a little bit now to non-congregate shelter, and we will come back. We're going to keep going back and trying to make sure that we answer all the questions, regardless of what category they are. But focusing now for a moment on non-congregate shelter, how can we support non-congregate shelter with supportive services? It's kind of related to what we were just talking about a minute ago.
Hi, this is David Jones. I'll take that one. So in the strictest of terms, supportive services do not support non-congregate shelter in the sense that HOME-ARP non-congregate shelter is the sticks and bricks, the building. However, supportive services can and should be provided to occupants of non-congregate shelters. And I think PJs that are planning to develop non-congregate shelters should also be looking at the benefits that the supportive services part of HOME-ARP can provide to the occupants. But as the question is phrased, supportive services do not support non-congregate shelter, if I'm understanding that question sort of in the most obvious way.
Wonderful. Okay, thank you. Okay, next question.
I'm sorry, this is Henrietta. I just wanted to add that, as folks know, you can't use HOME-ARP funds for the operating costs of the shelter, right? So that's a very clear, right, distinction. But the occupants of that non-congregate shelter can access supportive services if the PJ is providing it. But it cannot be operating for the non-congregate shelter. Just wanted to point that out.
Thank you. Yep, that's an important distinction. So thank you so much. All right. If HOME-ARP funds are used to construct non-congregate shelter, does the entire shelter or project need to be non-congregate? Can we use HOME-ARP funds to create non-congregate units in a facility that has both congregate and non-congregate space?
Yes, you cannot use HOME-ARP funding, non-congregate shelter funding to construct congregate shelter, but you certainly could carve out and prorate a portion of HOME-ARP funding for non-congregate shelter in what could be a multi-use structure or additional land that's available, next to an existing congregate shelter. So I think there are ways to do this together. You just have to prorate and make sure that you're not funding the congregate portion of the development with HOME-ARP non-congregate shelter, because we do not do congregate development with HOME-ARP.
This question says, I've combined HOME-ARP and CDBG for non-congregate shelter as a public facility. Is this problematic?
I'd like to hear more about it. I mean, not knowing the details of what is planned, if the person that asked that question, the PJ that asked it, would like to reach out to their field office, I think we would definitely like to talk about it. Just initial reaction is no, it's not problematic if they are using the CDBG funds in an eligible way and they're using the HOME-ARP funds in an eligible way, but there's not really enough information there to, I think, to provide an answer, but would certainly love to talk more about it.
All right, and kind of a related question. My city is looking to create a non-congregate shelter using HOME-ARP as a funding source. Since there will be multiple funding sources, I'm looking to understand which would be the most stringent as far as building codes. We want to know if there's a ratio of restrooms to rooms. And does that ratio apply only to units that are funded with HOME-ARP?
Okay, so building codes are going to be something that is determined local. So we're not going to have the ability based on what they're providing us to answer, we don't know where it's at. We don't know what they're planning. So that's not going to be something that we would touch on. Give me, there was more to that question, but
Yes.
try the rest of it. I was sort of
kind of the ratio to restrooms to rooms is under HOME-ARP, what that rule is as far as what's considered non-congregate shelter when it comes to restrooms. Each non-congregate shelter unit has to have at least one restroom.
That's right. So, I mean, again, speaking just strictly to bathroom facilities, there has to be a bathroom facility for each room and for the occupants of that room to have singular access to it. So there are no shared restroom facilities permitted with HOME-ARP.
Thank you so much. Okay, if HOME-ARP funds are used to construct non-congregate shelter, are all of the units required to meet HOME-ARP non-congregate shelter? I think you already answered this. Are all of them required to meet the HOME-ARP non-congregate shelter requirements if other funding sources are in the project?
Well, no, if there are other funding sources in the project, then you would have the ability to prorate units. They just wouldn't, if you plan to do something that does not align with the requirements of HOME-ARP NCS, you would need other funding sources to support that. You wouldn't be doing it with HOME-ARP. So yeah, that is a little bit of an overlap to the other one, if that's what that's. Yes, but you have the ability to mix and match in these developments in ways, and if you have other funding sources that do something different than HOME-ARP, nothing would prevent you from doing that in the same building. You just have to be able to distinguish between those units and show where the HOME-ARP NCS funding is going, and that it's only benefiting the qualifying populations that can be served under HOME-ARP.
Very good. All right, just a couple more questions and then we'll transition again. How do we document preferences for different QPs for non-congregate shelter activities?
Well, so first, the preferences would be supported in the allocation plan. So you'd show you'd have a need to serve a particular qualifying population or type of property, type of units that are needed locally. So you would have established that early on. You would then have preferences. If you are going to have preferences that you want to apply to a particular project, they would be included in the written agreement between the PJ and the owner of the development. I'm not sure if that's getting at what they're asking. How do they? Could you read the question again? Is that?
Yeah. How do we document preferences for different QPs and non-congregate shelter activities?
Do you want me to
Yeah,
jump in,
I mean,
David, from the
yeah,
preferences perspective?
yeah, if you'd like to.
Sure, yeah. So, this isn't limited to NCS, but when we're thinking about preferences, of course, they're required to be in the allocation plan. They're required to be in the written agreement with a project owner. So for NCS, it would be required to be in the written agreement, and then there is, a need to follow the specific referral method that's also established in the written agreement, right? And so a PJ is going to have policies and procedures. When you are defining a specific preference, it needs to be specific enough that it's clear what is the criteria to meet that preference, right? And so just like you're documenting eligibility with the QP definition, there's also going to be some sort of documentation that household meets the preference, because that's also going to be criteria for, to be eligible to kind of be bumped to the front of the list. And so it's really up to the PJ in setting preferences to be really specific about what that means. I've seen, a number of plans that do, I've said this a couple times, talk about the chronically homeless. What does that mean to your PJ? What are the specific criteria to be chronically homeless?
Thank you so much. I'm going to ask another question that's kind of related. This is around limitations. And I'm going to read it the way that it was written, but I'm not sure that this is the way that will make the most sense. Do most states submit non-congregate shelter as a limitation since the project is serving homeless and not at risk? So kind of rephrasing that for what I think they're saying is, from what you guys have seen, have there been many limitations implemented when it comes to non-congregate shelter and serving only homeless and not the at-risk of homeless QP?
I
I
think
Go
let
ahead.
me jump in, and then you go with what you think you've seen. What I would say is, what is the need to limit to the homeless? If folks, are already housed, are they going to end up, occupying a non-congregate shelter unit? No, right? They don't have the need for that unit. And so what is the need for the limitation? Clearly, in addition to having, certain eligibility and preferences, you also have to meet the need of the QP household. And if they have no need for that unit, they're not going to end up there. So it's really unnecessary in my opinion. And then David, I think we've probably seen some of it in advised PJs, but David, if you have a sense of whether you've seen that across all PJs, go for it.
No, I was just going to say that we just haven't seen that sort of narrowing. I think the NCS that we have seen is starting from, from the homeless population part of it. So no, I can't say that I've seen that, and I don't know if there's anyone else on the call that would recall if they've reviewed any. I can't say that I've seen that.
Yeah, I mean, I think I've probably seen it here and there, but I, when I've advised that it's not necessary, right? Why even set up those parameters?
Very good. Thank you so much. All right, going to turn it over to Jessica for a bit.
Perfect. So I'll ask a couple of rental housing questions. We've gotten a few more of those since we've been going. So HOME-ARP rental housing question: is a ground lease acceptable as site control?
Yes, a long-term ground lease would be an acceptable form of ownership as long as the ground lease is as long as the compliance period that's imposed on the property, which for HOME-ARP is a minimum of 15 years.
Great. And then, are there any sample written agreements for rental housing development that we can access?
We don't have sample written agreements, but as Henrietta mentioned, we do have in progress a TA product that is a checklist for developing a written agreement, which hopefully will be out shortly.
Great. Thank you. Okay. This is sort of an all topics question here. So regarding the implementation of layered components, would it be possible for the PJ to develop units under the development of affordable housing component and then tie along TBRA and or supportive services financial assistance for the rent charges? In this case, the PJ will develop and operate the affordable housing units.
So yes, actually that's sort of what we envisioned when we thought about HOME-ARP rental. So the ARP rental funds would go into the development of the unit. And then many tenants, if they're unable to cover rent, would receive tenant-based rental assistance. And then supportive services would be brought in to sort of assist the tenants, get back on their feet. So we did envision sort of a multi-layered approach to assisting the QP household.
Perfect. Now kind of going to some nonprofit operating and capacity building questions. What ideas should we consider when using capacity building? For grantees that have already been approved, they really would appreciate some real world suggestions.
Does provide some examples of capacity building assistance that's permissible. I don't know that, PJs have been approved for capacity building or have described exactly how they intend to assist a nonprofit with increasing capacity, but they can pay for training and staff for the staff of the nonprofit. They can costs can include salaries for new hires and other employee compensation. It's all about increasing the staff capacity, getting new skills, or possibly even equipment that would increase the nonprofit's capacity to be able to carry out a HOME-ARP project.
Wonderful. Another question, this one is about project delivery costs. So this particular person mentioned that they're having trouble understanding project delivery cost for subgrantees and nonprofit operating and capacity building. They note that their PJ didn't put any funding towards nonprofit operating and capacity building, but they are receiving applications for supportive services to support staff salary to undertake HOME-ARP projects, such as hiring additional case managers. And the second part of that question is, when does project delivery costs become capacity building for subgrantees?
So I'll start, and if others want to jump in, please do. So the nonprofit operating expenses and capacity building are not meant for covering the cost to carry out a specific activity or project. So delivering supportive services or TBRA, those are project delivery costs. So the soft costs, of the subrecipient or the PJ to carry out specific projects and activities can be included as project delivery costs, and that means that it's not necessary to use the admin set aside for those costs, but those costs have to be specifically tied to assistance that is provided to an eligible QP or a HOME-ARP project. If the costs are more general overhead costs and cannot be specifically tied to a rental project, the provision of supportive services, for example, to a QP, then they would have to be included in the admin costs. So there is a distinction between admin and project delivery, but it's really separate from what is meant by nonprofit operating capacity building assistance, which is to assist an organization to be able to carry out a HOME-ARP project.
All right, thank you so much. Let's go back. We have a couple questions going back to non-congregate shelter and substantial amendments. What's the trigger for a substantial amendment if you funded a half affordable rental project and a half non-congregate shelter project that wants to convert some of the non-congregate shelter into affordable rental before the end of the minimum use period? How many can we allow to be converted before we need to amend the allocation plan?
Wow, that's a big one, and I think they need to reach out. So first off, they can't convert as conversion is discussed in the notice. They can't convert during the minimum use period. So yeah, let's not even dig into this. They need to reach out to. They need to reach out to whoever they're dealing with in the field office, and we'll circle back and talk about it. But there's way too much there for the time that we have remaining.
Okay. All right. Does a developer have to have a bank loan versus his private funds, and do they have to report developer fees on like in a home project?
I assume this is related to a rental project. So as part of the PJ sort of underwriting of the project, right, they have to look at all the sources and uses, and often it includes both loans and developer equity. So that should all be reported to the PJ prior to when they execute the written agreement. What was the other question about? There was the bank loan versus
the private funds.
Yeah, and was there a third?
And do they have to report developer fees?
Yes, and so developer fees should also be included in the information that the PJ reviews for the underwriting prior to executing the written agreement.
Okay, great. All right, going back to rental now. Is there a minimum amount of home ARP that should be invested into construction related costs of rental housing project compared to the operating reserve? So, for example, should it be at least 50% of the total funds going into construction and the rest can go towards operating funds, or could it go as low as 10% going towards construction and the rest towards operating reserves? This is for rental.
Yes, actually saw this question pop up in the chat. So I'm not quite sure I understand what they're getting at. I mean, there are no sort of restrictions on the percentage of HOME-ARP funds that go into the development of the project versus, the operating reserve. It all is going to depend on the underwriting, the other funding sources that go into the project, and sort of what it's going to take to make sure that the project is financially viable for the full 15-year compliance period. You want to make sure if they're, in the pro forma, that there is a projected deficit associated with the QP units, that you have a way of covering the deficit, the project deficit associated, operating deficit rather, associated with those units, which would require you either providing ongoing operating cost assistance to the project or capitalizing a reserve up front. So I suggest if you, are sort of confused or need, more information about underwriting, that you, look for some of the TA products that will be coming out. But all of that will sort of be, worked out in the underwriting. The amount of development assistance that's needed and the amount of operating cost assistance that's needed to make the project viable.
Great, thank you. All right. We have about 8 minutes left. I'm trying to make sure we get to as many questions as possible. Is there any guidance on documenting in client files the eligibility, QP eligibility of a household?
So that will be the subject of our virtual clinic at the end of March. So please register.
Lots on that coming up. All right.
So I think we have a question here kind of related to IDIS and supportive services. And just wanting to get some clarity on the quarterly reporting for IDIS and supportive services. This particular question was talking about an agency that supports domestic violence victims. For context, if a client starts off homeless living in their car, but then is stabilized in a new rental unit, 2 months later, do we classify them as homeless or not homeless in that quarter?
Hi, this is Diane. I can answer that. They should report the household as homeless for the first quarter to capture its status when it initially is assisted. And if they continue to receive assistance after that quarter, then they should report that household as not homeless in the second quarter.
Great. All right. We'll take a few more questions here. This is kind of around layering, so it has a little bit of TBRA, a little bit of rental, a little bit of supportive services. Regarding the implementation of layered components, would it be possible for the PJ to develop units under the development of affordable housing component and then tie along TBRA and or supportive services? Financial assistance for the rent charges. In this case, the PJ will develop and operate the affordable housing unit.
I think we already answered that one, didn't we?
Oh, if so, I apologize.
I believe so. I had said that, that's sort of how we envisioned rental housing to work.
Exactly. Yeah. Perfect. All right. So we've got a question here around reaching out for TA. Who should I reach out to for TA? And I'm going to go back to this slide. We have only about 5 minutes left, so wanted to make sure that we share this and answer this question. For more HOME-ARP assistance, there are lots of things that are coming up. There's the quarterly office hours. You can also use the homearp@hud.gov email address. You can receive HOME-ARP program updates if you sign up for that HOME-ARP mailing list. And there's also direct TA that's available. PJs or field offices can request TA, and that would be through the TA portal on the HUD Exchange. So lots of different ways to get information, and we encourage everyone to get their questions answered. Also, reaching out to your local field office is always a good way to do it as well. All right. Jessica, do you see any other questions at the moment?
Just going through these. But, you know, just a couple of questions about products and things that are coming out. And like we said, and like a lot of our OAHP SMEs here, products are in the works, but we do want to make sure, you know, that you check out the HUD Exchange, make sure you're looking at some of the existing different webinars and TA materials that are on the HUD Exchange. There are some that are in the works, and we're working very diligently to get things uploaded and out to you as soon as possible, as Henrietta mentioned earlier in the presentation. So please just, you know, be on the lookout for those, sign up for those mailing lists and listservs so that as new information it becomes available, you are getting it right away. But I'm not seeing any other questions that we didn't at least get to indirectly. So I think we were able to get through most of this. And again, if you know you had a question in here that was really specific, we encourage you to continue to reach out to your field offices to get more guidance, especially if you have really complex questions that are local and specific. They are a wealth of knowledge and should be able to help you, or at least get you in touch with someone who can answer those questions for you. But Andalyn, I don't know if there's anything else we want to do or say, or have our HUD team close us out, but I think that was everything.
I think that's it. Thank you all for participating today, and want to thank the HUD staff again for taking the time out to give us these really great answers to the questions. That's it. Have a great day, everybody.